Here are some of the problems of getting an H-1B visa. Limited supply of visas. There is a cap of 65,000 H-1B visas issued each year, with an additional 20,000 visas available to foreign workers with advanced degrees from US universities. However, the number of applicants typically exceeds the number of visas available, resulting in a lottery system. High cost of sponsorship. Employers who sponsor H-1B workers are required to pay a variety of fees, including legal fees, H-1B visa fees, and prevailing wage determination fees. These fees can be significant, especially for small businesses. Complex application process. The H-1B visa application process is complex and time-consuming. Employers must file a petition with the U.S. Citizenship and Immigration Services, USCIS, and workers must submit a variety of documentation, including proof of education and work experience. Increased scrutiny from USCIS. USCIS has increased scrutiny of H-1B visa petitions in recent years, leading to an increase in denials. In addition to these general problems, there are a number of other challenges that workers may face in obtaining an H-1B visa, such as changing immigration policies. The US government has made a number of changes to its immigration policies in recent years, some of which have made it more difficult for foreign workers to obtain H-1B visas. Discrimination. Some workers may face discrimination in the workplace, which can make it difficult to find an employer who is willing to sponsor them for an H-1B visa. Family concerns. H-1B visa holders are generally limited to working for the employer who sponsors their visa. This can make it difficult for workers to move to new jobs or to relocate for family reasons. Despite these challenges, the H-1B visa remains a popular option for foreign workers who are seeking to work in the United States. It is important for workers to carefully consider their options and to consult with an experienced immigration attorney before applying for an H-1B visa. Cap-exempt H-1B visas are H-1B visas that are not subject to the annual cap of 65,000 visas. This means that employers can file cap-exempt H-1B petitions at any time of year, and there is no lottery system. There are a few categories of employers that are eligible to file cap-exempt H-1B petitions. Institutions of higher education. Non-profit entities affiliated with institutions of higher education. Non-profit research organizations. Government research organizations. Certain H-1B workers who have received J-1 waivers. In addition, the first 20,000 H-1B beneficiaries who have earned a master's degree or higher from a U.S. institution of higher education are exempt from the annual cap. There are a number of benefits to working for a cap-exempt H-1B employer. First, workers are not subject to the annual cap, so they are more likely to be able to obtain an H-1B visa. Second, cap-exempt H-1B petitions are typically filed and processed more quickly than cap-subject petitions. Third, cap-exempt H-1B workers are not required to maintain a job with their sponsoring employer in order to maintain their H-1B status. If you are a foreign worker who is interested in working in the United States on an H-1B visa, you should consider working for a cap-exempt employer. This can increase your chances of obtaining an H-1B visa and make the process easier and less stressful. Nurses and occupational therapists are scheduler occupations, which means that they are exempt from the H-1B cap. This is because the US government has determined that there is a shortage of qualified nurses and occupational therapists in the United States. The H-1B cap is a limit on the number of H-1B visas that can be issued each year. The cap is currently set at 65,000 visas, with an additional 20,000 visas available to foreign workers with advanced degrees from US universities. However, scheduler occupations are exempt from the cap, which means that employers can file H-1B petitions for nurses and occupational therapists at any time of year, and there is no lottery system. There are a few reasons why nurses and occupational therapists are exempt from the H-1B cap. First, the healthcare industry in the United States is facing a shortage of qualified workers. This is due to a number of factors, including an aging population, an increase in chronic diseases, and a shortage of nursing schools. Second, nurses and occupational therapists play a vital role in the healthcare system. They provide essential care to patients and help to improve the quality of life for people with disabilities. If you are a nurse or occupational therapist who is interested in working in the United States on an H-1B visa, you should contact a qualified immigration attorney to discuss your options. They can help you to determine if you are eligible for an H-1B visa and can assist you with the application process. Nurses who are sponsored for employment-based green cards (EB3) in the United States may be eligible for immediate approval of their I-140 petitions. This is because nurses are classified as Schedule A occupations, which are occupations in which the U.S. Department of Labor (DOL) has determined that there is a shortage of qualified workers. The I-140 petition is the first step in the green card process for foreign workers who are sponsored by employers in the United States. The petition must be approved by the U.S. Citizenship and Immigration Services (USCIS) before the worker can apply for a green card. Nurses who are sponsored for green cards may be eligible for immediate approval of their I-140 petitions if they meet the following criteria. They are working in a full-time, permanent position as a nurse in the United States. They have a valid state nursing license. They are sponsored by an employer who is willing to file a Form I-140 petition on their behalf. Their priority date is current. The priority date is the date that the USCIS receives the I-140 petition. The USCIS publishes a monthly visa bulletin that lists the priority dates that are currently being processed for each employment-based visa category. If a nurse meets all of the above criteria, they may be eligible for immediate approval of their I-140 petition. This means that the USCIS will approve the petition without having to conduct a labor certification process. Once the I-140 petition is approved, the nurse can apply for a green card. If the nurse is currently in the United States, they can apply for adjustment of status to green card holder. If the nurse is outside of the United States, they will need to go through consular processing to obtain their green card. It is important to note that nurses who are sponsored for green cards may still be subject to other processing delays, such as background checks and medical examinations. However, immediate approval of the I-140 petition can significantly expedite the green card process. Yes, nurses are generally able to get green cards before tech workers. This is because nurses are classified as Schedule A occupations, while tech workers are not. Scheduler occupations are occupations in which the U.S. Department of Labor (DOL) has determined that there is a shortage of qualified workers. As a result of this classification, nurses are eligible for a number of benefits, including exemption from the H-1B cap, immediate approval of I-140 petitions, priority processing of green card applications. These benefits can significantly expedite the green card process for nurses. Tech workers, on the other hand, are not classified as Schedule A occupations. This means that they are not eligible for the same benefits as nurses. As a result, tech workers may have to wait longer to get their green cards. It is important to note that the green card process is complex and can vary depending on a number of factors, such as the worker's country of origin, the type of green card they are applying for, and the current processing times at the USCIS. However, in general, nurses are able to get green cards before tech workers. If you are a nurse or tech worker who is interested in learning more about the green card process, you should consult with a qualified immigration attorney. They can help you to determine your eligibility for a green card and can assist you with the application process. Indian tech workers get green cards approved in 1 year if they start working as a nurse then switch to tech worker. Or Indians can go to Canada or Mexico for permanent residency and citizenship then migrate to America with TN-NAFTA visa. Indian nurse with priority date of January 1, 2022 and Indian tech worker with priority date of January 1, 2009 both have current priority date. Can they both get green card permanent residency at the same time? Yes, both the Indian nurse with a priority date of January 1, 2022 and the Indian tech worker with a priority date of January 1, 2009 are eligible to file for and receive a green card permanent residency at the same time, as long as they meet all other eligibility requirements. The priority date is the date that USCIS receives your immigrant visa petition. It is used to determine when you are eligible to file for adjustment of status or an immigrant visa. The visa bulletin is published monthly by the U.S. Department of State and shows the priority dates for each immigrant visa category. If your priority date is current, you may file for adjustment of status or an immigrant visa, regardless of your country of chargeability. The fact that you are both Indian nationals is irrelevant to the priority date system. All immigrants, regardless of their country of origin, are processed in order of their priority date. However, it is important to note that there is a backlog in processing green card applications for certain immigrant visa categories, including the EB3 category for skilled workers. This means that even if your priority date is current, you may have to wait several months or even years for your application to be processed. Here is a summary of the steps you need to take to apply for a green card permanent residency as an Indian nurse with a priority date of January 1, 2022. 1. Make sure your priority date is current by checking the visa bulletin. 2. File Form I-485, application to register permanent residence or adjust status. 3. Gather all supporting documentation, such as a copy of your I-140 petition, medical exam results, and affidavit of support. 4. Pay the filing fees and submit your application to USCIS. Once you have submitted your application, USCIS will schedule a biometrics appointment and interview. If your application is approved, you will be issued a green card. If you have any questions about the green card application process, you should consult with an experienced immigration attorney. Yes, the nurse with a priority date of January 1, 2022 and whose priority date is current would get her green card approved before a tech worker with a priority date of January 1, 2010 whose priority date is not current. This is because USCIS processes green card applications in order of priority date. This means that immigrants with earlier priority dates are processed first, regardless of their country of origin or immigrant visa category. The fact that the nurse's priority date is current means that a visa number is immediately available for her. This means that her green card application can be processed and approved as soon as USCIS has completed its review of her application. The tech worker's priority date is not current because there are more immigrants with earlier priority dates who are waiting for a visa number. This means that the tech worker will have to wait until his priority date becomes current before his green card application can be processed and approved. The backlog in processing green card applications for certain immigrant visa categories, including the EB3 category for skilled workers, can be several months or even years. This means that the tech worker may have to wait a long time before his priority date becomes current and his green card application can be processed and approved. It is important to note that there are some exceptions to the priority date system. For example, certain immigrants, such as immediate relatives of US citizens and certain special immigrant juveniles, may be eligible to file for a green card even if their priority date is not current. If you have any questions about the green card application process or the priority date system, you should consult with an experienced immigration attorney. Yes, you are correct. The priority date for nurses is currently current, including Indian nurses, meaning that nurses with priority dates in 2022 and earlier are eligible to file for and receive a green card permanent residency at the same time, as long as they meet all other eligibility requirements. This means that a nurse with a priority date of January 1, 2022 is likely to be able to get a green card much faster than an Indian tech worker with a priority date of January 1, 2010 whose priority date is not current. There are a few reasons for this. First, nurses are classified as scheduler occupations, which means that the US government has determined that there is a shortage of nurses in the US. This means that nurses are given priority in the green card process. Second, the AB3 visa category for skilled workers has a backlog of more than 10 years, while the AB2 visa category for nurses has a much shorter backlog. This means that nurses are likely to have to wait less time for their green card applications to be processed and approved. It is important to note that the priority date system is complex and there are many factors that can affect the processing time for a green card application. However, in general, nurses are likely to be able to get a green card much faster than tech workers. If you are a nurse and you are interested in immigrating to the US, you should consult with an experienced immigration attorney to discuss your individual situation and the best path to immigration for you. Yes, you can switch to a tech job if you are on an I-140 as a nurse. The I-140 is a petition filed by an employer to sponsor a foreign national worker for permanent residency in the United States. Once the I-140 is approved, the employee beneficiary has a priority date, which is the date the Perm Labor Certification was filed or the date the I-140 petition was filed for scheduler workers. This priority date determines where the employee stands in line for their green card. If you have an approved I-140 as a nurse, you can switch to a tech job without having to start the I-140 process over. However, there are a few things to keep in mind. The new tech job must be in a similar occupation. For example, a software engineer position would be considered a similar occupation to a nurse, but a customer service position would not be considered a similar occupation. The new employer must be willing to sponsor you for a green card. The new employer must file a new PERM labor certification, unless you are a scheduler worker. You must maintain your H-1B status while you are waiting for your green card. If you are considering switching to a tech job, it is important to consult with an immigration attorney to discuss your specific situation. Here are some tips for switching to a tech job on an I-140 as a nurse. Network with people in the tech industry. Attend industry events, connect with people on LinkedIn, and reach out to friends and family who may know someone in the tech industry. Highlight your transferable skills. Nurses have many skills that are valuable in the tech industry, such as problem solving, teamwork, and communication. Be sure to highlight these skills in your resume and cover letter. Be prepared to take on entry-level positions. If you do not have any tech experience, you may need to start in an entry-level position. Once you have gained some experience, you can then start applying for more senior positions. Get certified. There are a number of tech certifications that you can earn, such as the CompTIA A+ or the Google Cloud Certified Professional Cloud Architect. Getting certified can make you more competitive in the job market. Switching to a tech job can be a great way to advance your career and earn a higher salary. However, it is important to do your research and plan carefully before making the switch. Yes, you can work part-time on an I-140. The I-140 is a petition filed by an employer to sponsor a foreign national worker for permanent residency in the United States. Once the I-140 is approved, the employee beneficiary has a priority date, which is the date the PERM labor certification was filed or the date the I-140 petition was filed for scheduler workers. This priority date determines where the employee stands in line for their green card. There is no requirement that you work full-time on an I-140. However, you must maintain your H-1B status while you are waiting for your green card. This means that you must work for the employer who sponsored your I-140, and you must work at least 20 hours per week. If you are considering working part-time, it is important to talk to your employer and your immigration attorney. Your employer must be willing to reduce your hours, and your immigration attorney can advise you on how to maintain your H-1B status. Here are some tips for working part-time on an I-140. Talk to your employer about your options. Be honest about your needs and see if there is a way to work part-time while still meeting the requirements of your H-1B status. Get everything in writing. Once you have reached an agreement with your employer, be sure to get everything in writing. This will help to protect you in case of any problems down the road. Maintain your H-1B status. Make sure that you continue to meet all of the requirements of your H-1B status, including working at least 20 hours per week. Stay in touch with your immigration attorney. Keep your immigration attorney informed of your situation and ask for advice if you have any questions. Working part-time on an I-140 can be a great way to balance your work and personal life. However, it is important to do your research and plan carefully before making the switch. Yes, you could work part-time as a nurse on an I-140 and full-time as a tech worker. However, there are a few things to keep in mind. You must maintain your H-1B status. This means that you must work for the employer who sponsored your I-140, and you must work at least 20 hours per week. You must have the permission of both employers to work two jobs. You must be able to manage your time effectively and meet the demands of both jobs. If you are considering working two jobs, it is important to talk to your employers and your immigration attorney. Your employers must be willing to accommodate your schedule, and your immigration attorney can advise you on how to maintain your H-1B status. Here are some tips for working two jobs on an I-140. Be upfront with your employers about your plans. Let them know that you're considering working two jobs and ask for their permission. Be organized and efficient with your time. Create a schedule that allows you to meet the demands of both jobs. Be prepared to work hard. Working two jobs can be challenging, but it is possible if you are willing to put in the effort. Working two jobs can be a great way to earn extra money and gain experience in two different fields. However, it is important to do your research and plan carefully before making the switch. You need to reapply for H-1B if you are switching jobs, even if you have an approved I-140. The I-140 is a petition filed by an employer to sponsor a foreign national worker for permanent residency in the United States. Once the I-140 is approved, the employee beneficiary has a priority date, which is the date the perm labor certification was filed or the date the I-140 petition was filed for scheduler workers. This priority date determines where the employee stands in line for their green card. The H-1B visa is a non-immigrant visa that allows foreign nationals to work in specialty occupations in the United States for up to 6 years. To be eligible for an H-1B visa, the employee must have a bachelor's degree or the equivalent in their field of specialization, and the job offer must meet certain requirements, such as requiring a bachelor's degree and paying the prevailing wage for the position. When you switch jobs, your new employer must file an H-1B transfer petition on your behalf. The H-1B transfer petition must be approved before you can start working for your new employer. The H-1B transfer process is typically shorter than the initial H-1B application process, but it is still important to start planning early. Here are some tips for reapplying for H-1B when switching jobs. Start planning early. The H-1B visa application process can be complex and time-consuming, so it is important to start planning early. Work with an immigration attorney. An immigration attorney can help you navigate the H-1B visa application process and ensure that your application is complete and accurate. Gather all of the required documentation. The required documentation for an H-1B transfer petition includes a copy of your passport, a copy of your I-140 approval notice, and a copy of your job offer from your new employer. Submit your application early. The H-1B visa cap is reached every year, so it is important to submit your application as early as possible. If you have an approved I-140, you are not subject to the H-1B visa cap. However, you still need to have an approved H-1B visa in order to work in the United States. Yes, that is correct. You could work for a year as a nurse on H-1B, then get your I-140 approved, then work as a nurse until you find a tech job and switch your H-1B, while keeping your perm priority date. This means that you could be working as a tech worker and optionally continue to work part-time as a nurse in about 2 years. Here is a possible timeline. Year 1. Work as a nurse on H-1B. Year 2. Get your I-140 approved. Year 3. Continue to work as a nurse until you find a tech job. Year 3. End. Switch your H-1B to work as a tech worker. Year 4. Work as a tech worker and optionally continue to work part-time as a nurse. It is important to note that this is just a possible timeline. The actual amount of time it takes to switch from an I-140 nurse to a tech worker can vary depending on a number of factors, such as the availability of tech jobs, your qualifications and experience, and the processing time for H-1B transfers and perm labor certifications. It is also important to note that you must maintain your H-1B status while you are waiting for your green card. This means that you must work for the employer who sponsored your I-140, and you must work at least 20 hours per week. If you are considering switching from an I-140 nurse to a tech worker, it is important to talk to your employer and your immigration attorney. They can help you understand the process and develop a plan that is right for you. The wait time for green cards for Indian tech workers is currently very long, due to a number of factors. First, there is a large backlog of green card applications, and the United States Citizenship and Immigration Services (USCIS) is processing applications in the order in which they were received. This means that Indian tech workers who have recently applied for green cards will likely have to wait a long time for their applications to be processed. Second, there is a per-country limit on the number of green cards that can be issued each year. This limit is designed to ensure that green cards are distributed fairly among people from all over the world. However, it also means that Indian tech workers may have to wait longer for green cards than workers from other countries with smaller green card backlogs. Third, the USCIS has been experiencing staffing shortages in recent years. This has led to delays in the processing of all types of immigration applications, including green card applications. Finally, the US government is considering a number of changes to the immigration system, including changes to the green card process. It is unclear how these changes will affect the wait time for green cards for Indian tech workers, but they could potentially lead to even longer wait times. Despite the long wait times, there are a number of things that Indian tech workers can do to improve their chances of getting green cards sooner. First, they can make sure that their green card applications are complete and accurate. Second, they can work with an experienced immigration attorney who can help them to navigate the green card process. Third, They can consider applying for other types of visas, such as H-1B visas or O-1 visas, which can allow them to stay and work in the United States while they wait for their green cards to be processed. If you are an Indian tech worker who is considering applying for a green card, you should consult with a qualified immigration attorney to discuss your options. They can help you to assess your eligibility for a green card and can assist you with the application process. There are a number of factors to consider when deciding whether to go to Canada first to get Canadian permanent residency and citizenship and then come to America for work on AT&T NAFTA visa, or to wait for an American green card. Advantages of going to Canada first. Faster processing times. The processing times for Canadian permanent residency are typically faster than the processing times for American green cards. More lenient requirements. The requirements for Canadian permanent residency are generally more lenient than the requirements for American green cards. For example, Canada does not have a per-country limit on the number of green cards that can be issued each year. Pathway to U.S. citizenship. Once you have obtained Canadian citizenship, you are eligible to apply for U.S. citizenship through the EB-1 visa category. This category has a very short processing time and does not require sponsorship from an employer. Disadvantages of going to Canada first. Cost. The cost of immigrating to Canada can be significant, especially if you have a family. Job market. The job market in Canada is not as large or as competitive as the job market in the United States. Language barrier. If you do not speak French or English, you may face a language barrier in Canada. Advantages of waiting for an American green card. Salary. Salaries in the United States are generally higher than salaries in Canada. Job opportunities. The job market in the United States is larger and more competitive than the job market in Canada. Diversity. The United States is a more diverse country than Canada, which may be appealing to some people. Disadvantages of waiting for an American green card. Long processing times. The processing times for American green cards can be very long, especially for Indian tech workers. Strict requirements. The requirements for American green cards are generally more strict than the requirements for Canadian permanent residency. No pathway to Canadian citizenship. If you are waiting for an American green card, you are not eligible to apply for Canadian citizenship. Ultimately, the decision of whether to go to Canada first to get Canadian permanent residency and citizenship and then come to America for work on AT&T NAFTA visa, or to wait for an American green card is a personal one. There are a number of factors to consider, such as your financial situation, your career goals, and your personal preferences. If you are still unsure which path to choose, you should consult with an experienced immigration attorney. They can help you to assess your eligibility for both Canadian permanent residency and American green cards, and they can advise you on the best course of action for your individual situation. There are a few reasons why it may be better to go to Mexico first to get permanent residency and citizenship and then come to America on AT&T NAFTA visa, rather than going to Canada first. Cost. The cost of immigrating to Mexico is typically lower than the cost of immigrating to Canada. Language barrier. If you speak Spanish, you will not face a language barrier in Mexico. Proximity to the United States. Mexico is closer to the United States than Canada, which makes it easier to travel between the two countries. However, there are also some potential disadvantages to going to Mexico first. Safety. Mexico has a higher crime rate than Canada. Job market. The job market in Mexico is not as large or as competitive as the job market in Canada. Pathways to U.S. citizenship. There are no direct pathways to U.S. citizenship for Mexican permanent residents. Instead, Mexican permanent residents must apply for green cards through the traditional employment-based or family-based visa categories. Overall, the decision of whether to go to Mexico first or Canada first to get permanent residency and citizenship is a personal one. There are a number of factors to consider, such as your financial situation, your career goals, and your personal preferences. If you are still unsure which path to choose, you should consult with an experienced immigration attorney. They can help you to assess your eligibility for both Mexican permanent residency and Canadian permanent residency, and they can advise you on the best course of action for your individual situation. It is important to note that the TN NAFTA visa is a temporary work visa. It does not lead to permanent residency in the United States. However, TN visa holders may be eligible to apply for green cards through the traditional employment-based or family-based visa categories. The TN-NAFTA visa allows citizens of Canada and Mexico to live and work in the United States in prearranged business activities for U.S. or foreign employers. However, it does not lead to permanent residency or citizenship in the United States. To be eligible for a TN-NAFTA visa, you must be a citizen of Canada or Mexico and your profession must be on the NAFTA list of professions. You must also have a job offer from a U.S. employer and meet the specific requirements of your profession. If you have Canadian or Mexican citizenship and a TN-NAFTA visa, you may be able to live and work in the United States indefinitely, as long as you continue to work in a prearranged business activity for a U.S. or foreign employer. However, you will not be eligible for permanent residency or citizenship in the United States based on your TN-NAFTA visa alone. To obtain permanent residency in the United States, you will need to apply for a green card through a different visa category, such as the employment-based visa category or the family-based visa category. If you are interested in starting a business in the United States, you may be able to do so on a TN-NAFTA visa. However, you will need to meet certain requirements, such as having a majority ownership interest in the business and being actively involved in the management and operation of the business. It is important to note that the TN-NAFTA visa is a complex visa and there are many factors to consider when applying for one. It is always best to consult with an experienced immigration attorney to discuss your specific situation and to ensure that you meet all of the eligibility requirements. Here are some additional things to keep in mind. TN-NAFTA visa holders are not eligible for certain government benefits, such as Social Security and Medicare. TN-NAFTA visa holders are subject to U.S. immigration laws and may be deported for violating those laws. TN-NAFTA visa holders may apply for a green card through the employment-based visa category, but they may face a long wait time, especially if they are from a country with a high backlog of green card applications. If you are considering using a TN-NAFTA visa to live and work in the United States, it is important to weigh the pros and cons carefully. You should also consult with an experienced immigration attorney to discuss your specific situation and to ensure that you understand all of the requirements and limitations of the TN-NAFTA visa. Indians who applied for EB2 or EB3 green cards and are on H-1B visas currently have a priority date that is 2009, almost 15 years. This means that they have been waiting for their green cards for over a decade. There are several reasons why this is a problem. Difficulty transferring jobs. H-1B visas are tied to a specific employer. If an H-1B visa holder wants to switch jobs, they must find a new employer who is willing to sponsor them for an H-1B visa. This can be difficult, especially for H-1B visa holders with long priority dates, as employers are often reluctant to sponsor employees who may have to wait many years for their green cards. Difficulty getting promoted to management. H-1B visas are intended for workers in specialty occupations. This means that H-1B visa holders may have difficulty getting promoted to management positions, as management positions may not be considered specialty occupations. Difficulty switching to jobs outside of their specialty occupation. H-1B visa holders are generally not allowed to switch to jobs outside of their specialty occupation. This can limit their career options and make it difficult for them to find jobs that match their skills and interests. Difficulty keeping an employer to sponsor them for 15 years for a green card. It can be difficult for H-1B visa holders to keep an employer to sponsor them for 15 years for a green card. Employers may have financial difficulties, may go out of business, or may simply decide not to sponsor their employees for green cards. America with a master's degree only. In addition to these challenges, Indians who are students who come to America with a master's degree only have a 5 to 7% chance of actually getting a green card. This is because the AB2 and AB3 categories are oversubscribed, and there are more qualified applicants than there are visas available. Overall, the current situation for Indians who are on H-1B visas and are waiting for green cards is very difficult. They face many challenges, and they have a long wait ahead of them. Here are some additional thoughts on the matter. The long wait times for green cards can create a lot of uncertainty and stress for H-1B visa holders. They may be hesitant to start families, buy homes, or make other long-term plans because they do not know when or if they will be able to stay in the United States permanently. The long wait times can also make it difficult for H-1B visa holders to compete in the job market. Employers may be less likely to hire H-1B visa holders who have long priority dates, as they know that they may have to wait many years for their green cards. The long wait times can also have a negative impact on the US economy. H-1B visa holders are highly skilled workers who contribute to the US economy in many ways. However, if they are unable to get green cards and have to leave the United States, the US economy will lose their talents and skills. The US government has taken some steps to address the long wait times for green cards, such as increasing the number of visas available in the EB2 and EB3 category.